Hello, this is Rex Crandell, and the topic for today is what's the importance of a durable power of attorney and who needs one? And it's part of a estate planning series. There's several types of powers of attorney. I'll cover them and then get into more detail how they relate to estate planning. There's a general power of attorney that someone signs giving another person the authority to do anything that they need to manage your assets, sign contracts, pay bills. And the general power of attorney is void if you become incapacitated. You become mentally incapacitated, like Alzheimer's, and the general power of attorney is no longer effective. There has to be special wording in the document that says that it survives incapacity. Otherwise, it will not, and it'll be void at that point. So you're appointing a principal, you're the principal, you're appointing an agent to act on your behalf, and you decide how much authority you want to grant that individual or more than one individual. So like handling transactions, paying bills, negotiating contract, hiring, firing, managing a business, stock, bond sales, all those types of items can be granted to an agent under a power of attorney. So that was the general power of attorney. Now let's look at the limited power of attorney. A limited power of attorney means that you're specifying only the exact acts that you want your agent to do for you. It limits it. Let's say you were traveling to Europe and you had to close a real estate escrow and they were not using DocuSign, and you wanted a person to sign the closing papers. Well, a limited power of attorney, you could just say, I want you to sign the closing papers and limit it to that act. Okay, and both the general and limited powers of attorney are ineffective on incapacity unless they have that special wording. The next type of power of attorney is more important for estate planning, and it's called a durable power of attorney. And no, it's not printed on tough paper like cardstock. It's what it means by durable is that it's still effective if a doctor renders an opinion that you are incapacitated, mentally incapacitated. So the document's prepared and the effective date is up to you. You can either have the durable power of attorney effective now, or you can have it springing, which means when a doctor determines you're incapacitated, that now that it's effective. So those are the two types of options, and it's authorized under California Probate Code 4129. There's another type of power of attorney, but most people don't call it by that term. It's for medical. If you become incapacitated, can't talk to your doctor, the doctor is not going to talk to you, or another person, I should say, even your spouse, unless you have an advanced health care directive that you've granted authority for someone else to make medical decisions for you. Now, when a person becomes incapacitated without a durable power of attorney, then it causes a problem because banks and financial institutions won't recognize anyone else, and being married doesn't stop the problem. What they will require is that you go to court and obtain a conservatorship, someone appointed by the court, and then it's all the requirements of that, accounting every other year, a lot of legal work, just that could have been avoided with a simple document prepared as part of a estate plan. Now, if you have a comprehensive estate plan with a revocable trust, a will that pours over into the trust, a durable power of attorney for asset management, and a advanced healthcare directive, if you become incapacitated, two things happen. You are removed as trustee of your revocable trust, and the successor trustee takes over. And at that point, your durable power of attorney for financial management takes over. So any assets that are outside of your trust are managed by the DPOA. Any assets in your trust are managed by the successor trustee. Normally in an estate plan, we have those two roles be the same person. Okay, so you can elect what rights you give to your agent. And this process is not to be confused with a partnership where you have liability for another person, sharing profits. The agent is a fiduciary and can only take acts or do things that benefit you. It's a requirement by law. In order to have a valid durable power of attorney, it has to be executed in one of two ways. Either a notary watches you sign the document, or you have it signed before two witnesses in the same room at the same time. This is required under Probate Code 4121. We always notarize the durable power of attorney for asset management because when you're dealing with banks and financial institutions, you don't want to give them any more reason to not cooperate with you and your estate plan. The question is, can you revoke your attorney in fact, power of attorney? Yes, at any time. It's better if you do it in writing, better if it's notarized. Can you name more than one agent under a durable power of attorney? Yes, you can. You can name alternates. So let's say you have a brother and a sister, you could name them both. One requirement under California law is that you must have the agent sign the durable power of attorney document before they take any action within the state. So you can either have them sign it now, or if your durable power of attorney is springing on incapacity, when they start acting as your agent, they can sign at that time. So the durable power of attorney for asset management should include all matters, including tax, if you authorize that in your document. However, the IRS is somewhat particular all the time, and it would be preferable if you had an IRS form 2848, the IRS attorney in fact form, for use in doing tax returns. And the way that an agent signs under a durable power of attorney or attorney in fact is they sign your name, and then it says by their name, comma, attorney in fact. So they're not forging your signature or doing something like that. You can also grant your agent the authority to delegate to another person to act if they're going to be unable to act for you for a certain period of time. Another thing that we always do is name a successor and an alternate successor to the agent position, and have a mechanism so beneficiaries or family members can elect another person to act as agent if those other agents are no longer available. So this is a brief overview of the durable power of attorney for asset management. If you have any questions, you can contact us at the Rex Crandell firm. Our phone number is 1-800-464-6595. And our email address is rexcrandell@astound.net, ASTOUND.net. Thank you for listening.